You still want that protected. It kind of works in the reverse. You want the LLC to protect its own property, and then at the same time protect the property of the people that are in the company. And let me just kind of point out some things that I've seen that people again run into. We talked about how we sign the contracts a little bit before. What we've also seen, and what I've also seen in the past, believe it or not, is people are under the impression that a piece of property is owned by their LLC, and it's really not. And you know, there could be somebody who's just new to the industry, doesn't know the ins and outs, but hey, I went out and got a loan in my own name, and I didn't realize that the deed of the property went into my own name. It seems simple, but you know, if there's any doubt about that, just ask somebody. You know, there's plenty of people out there willing to help you. But obviously, if you don't do that, that's one of the most important things, that is not going to be protected. That piece of property by the LLC, it's going to be owned by you. So, same thing with deeds. I don't see this as much, but you know, a lot of times people will want to you know, deed a property to the LLC, but unfortunately, it's only after they bought their own name. That can be done, but it's very important to coordinate that check first with your mortgage lender. Because a lot of, and this tends to be true more with personal residents, but it can apply anywhere. You normally cannot just go and deed something to the LLC, because that LLC is considered to be a separate person in a sense, as far as the law is concerned. And if you look in most mortgages, most deeds of trust, it'll say if you convey this property to anybody else, we can call the loan. So plenty of people do that, but it's really important to check first and just know what you're doing. And you know, you might have a lender that says absolutely not. You might have another lender that says, well, maybe we'll do that under some circumstances, but you know, here are the rules you have to follow to do that. So just be aware of that. And so, you know, when people buy the property in their own name first, the way around that is, well, you know, let me explore if I have an LLC already set up before I go into this. Will somebody make a loan to my LLC as the owner of the property that you don't have to worry about that? And unless your LLC is on the scale of Walmart, almost always the bank's going to make you personally guarantee something. And that goes to others, so it's a sole member LLC. But that's fine. Even if that's the case, you'll still have the property in the name of the company. And that's the idea. Some people, and these two issues are kind of tied together a little bit. Some people set up one LLC, they become a very active investor, and they put too many properties in the LLC. Think of it like a house of cards. You don't want to do that. Now, on the flip side, you don't necessarily need to get extreme. If you have 15 pieces of property, you might get very burdensome to have 15 different LLCs, but just try to strike that common sense balance. She's telling me to wrap up here. Again, the most important thing to remember, if you have a question, just ask. There's, you know, it's a cliche, but there's no stupid questions, and it's always so much better to talk to an attorney before something goes south than after.
The LLC, the trustee, and the land trust.
Yes.
And also, then a different LLC is beneficiary.
Yes. Now, you know, anytime you get into doing something like that, you're also going to want to talk to the CPA. Legally, just because something can be done, sometimes it may not be the best thing for your situation, tax-wise. So, but we also have LLCs. They're only members of the LLC or actually other LLCs. Depends on how you want to set it up. So.
All right.
You mentioned, Joe, the issue of fixing the corporate veil if you're entangled the resources from your personal life and your business.
Potentially.
Are there any states where it's easier or more difficult to do so that you know?
It's not, I mean, it's hard to make a general statement like this. Generally, it's very hard to do that in Virginia. It's not easy because our courts have a policy of respecting the corporation, the LLC, once somebody's done that. And Virginia's, I would suspect, and I can't directly speak for other states, but I suspect we're probably one of the more business-friendly states when it comes to that. If you look at the cases over the years, you almost have to show that somebody set up the LLC for a fraudulent purpose. You know, hey, I went out and I formed an LLC, paid my $50 to the state and $75. I went, took out Papa says it happens very often in real life, but that's the kind of thing that they're looking for. And all these other things that I'm talking about, think of it like that's just more evidence of a bad intent. Maybe a better way to look at it.
I was doing some research and I'm a little confused. They say that starting out or a holding company or something called Miami protects you a little bit more, and then you could probably get an LLC somewhere else. Can you give me a little more clarity on where I can protect myself? Where I know the state of Florida's all your information is out there. In this state somewhat as well, but I'm looking for something like what I heard in Miami, where something more private.
I mean, as far as privacy goes, well, one advantage of an LLC here is that the information that the state corporation commission has, that anybody can go and look at, all that contains is what we call your registered agent. So that could be you know, if you're a sole member LLC, it could be an attorney that you use. And if you have someone who, for some reason, want to keep my name as far away from this as possible, it doesn't have to be for bad reasons. The LLC is much more private in that sense. With a corporation, for example, I can pull up the records from the SEC and I can tell you who all the directors are. Not the shareholders, but you know, it's incremental. So now I don't know. In some states, obviously, they're going to be different, and some states it's harder to do things like collective judgment against the company. That's generally how it works.
I have a question.
I'll give everyone cards. Okay. Yes, sir.
Scenario.
Okay.
All right, family owns property for 10 years. Family buys another property.
Now you say family, you mean everybody owns their own name? Or?
Right, so they own. Right?
Okay.
So they buy another property, move into the property, but then they rent out property, but it's still under Social Security. So how do you get that property into an LLC?
Are you talking about property that somebody inherited? That's why you have like a bunch of family members that own it, or they just bought it together?
Just own, right? So
If they're on, let's say you got four family members that own it, and the deed is in their names, all four of those people have to sign a deed to the LLC. That's how you get it into the LLC's name.
okay, so you sign the deed.
You have to deed it to the LLC. And that's the case, even if all four of those same people are the only ones in that LLC. It's considered to be a separate legal entity, separate person. It's the way to think about it, even though it's not a person.
Yeah, that's done through the title company or.
It's done just like any other closing. I mean, it can be informal in the sense you can do what we call a deed of gift or something like that. It doesn't have to be as full blown closing as when you go out and get a loan, but it is a distinct transaction that has to be done.
Well, what if it's still as a mortgage?
Well, that's what I was getting at earlier, is you gotta be careful, because if whoever holds that mortgage decides that violated the deed of trust because it's advanced to a separate entity, you could run into problems with calling loan.
A lot of good information, Thank you.
Oh, no,
Yeah.
we've got more.
Okay.
All right, thank you very much.
Mr. Streeter, give some business cards out. You guys have any other questions? You want to chat with him? Great guy. Thank you.
Our next speaker is Sarah. Take it away.
Hi, good evening. I hope everyone is doing well. If I may be allowed to screen share, I will start a presentation. While I'm waiting to do that, my name is Sarah McCurry. I'm a partner in the law firm of Winslow, McCurry, and McCormick. We are a law firm with our offices in Sycamore Square, but we represent clients throughout the Commonwealth. I also am a Florida attorney, and I represent clients throughout the state of Florida as well. So tonight I have the pleasure of talking to you about estate planning in Virginia, right?
Oh,
It's a
she
very
just did a
basic introduction. Normal lawyer disclosure, right? This is general advice. Every estate, every LLC from the previous, every situation is different, and it's going to require a conversation regarding your specific situation. And I'm sure any of the attorneys that are talking to you tonight would be more than happy to do so. So what's the first step? What do I want to do to protect my assets, right? The first thing that you need to figure out is always who owns what and how, right? In the context of real estate, you have to look at the real estate and you say, how is it titled? Is it titled in the name of a company? Is that company an LLC? Is it a corporation? And if it is, who owns that company and how is that company governed, right? Because if you're going to be able to know how and when and where assets will go, if something happens to you, you need to know what rights you have to do so. You can look at documents such as operating agreement, shareholder agreement, whatever kind of governing documents you have for your company, right? If that property is titled in individual names, you're looking at the deed. Okay, you're saying, okay, if the property is owned by an individual, is it in an individual's name? Is it in a name of a trust? Is it held joint tenants? Is it held where there is an assumed by law way that asset would automatically transfer? Or is it just yours and whatever you say in your documents that you want it to go, that's what's going to control? What does your will say about where do assets go? So all of these questions are things that have to be asked, okay? What controls? And so in order to do a complete estate plan, you're always going to want to look at all of your assets. You're going to want to look at deeds. You're going to want to look and see if you have a will, if you have a trust. But you also don't want to forget about beneficiary forms. Beneficiary forms have a lot of power. And then, I already was talking about joint ownership. Putting the right plan in place will be completely contingent on you and your situation in your family. When I do an estate plan, the first thing I like to do is learn about the individual, and then go through and talk to them about the assets that they have. And just like I already said, how are they titled? Who has them? Where are they? An estate plan is made up of different documents. Not everybody's estate plan is the same because everybody's family is different. So your estate plan could, and most of the time should, include a will. It may include a trust, whether it be revocable, which means during your lifetime or during the lifetime of you and your spouse, you have the ability to, or whoever else is on the trust, you have the ability to make changes. You can change who and when and what and why and how. You have those abilities. An irrevocable trust is a trust where you put terms in place, and unless there's always an asterisk in law, right? Unless certain things happen, it's going to stick, right? That's what's going to, the assets are going to stay in there. The assets are going to be distributed the ways that you say in that document the day that you sign it. You're going to look at the deeds. You're going to look at whether, it makes sense to gift property to someone, whether it makes sense to grant someone a life estate or retain a life estate. There's transfer on death deeds. So all of these are just tools that you can look at. Anytime you're putting an estate plan in place, it's also important to talk about what your beneficiary forms say. So any type of contract that you have with the bank, whether it's any type of checking, savings, money market, CD account, whether it's an investment account, or whether it's life insurance, all those things have beneficiary forms on them, right? And so making sure that that is part of your puzzle as well is always important. The biggest question that I'm asked is, if you don't have a will, what happens, right? Because a will is an instrument that you can put in place and say, this is where I want my assets that are not controlled otherwise to go. If you don't have a will, the law will make decisions for you, right? So the intestate laws will choose how your assets will be distributed. If you have minor children, they will decide who will be able to take guardianship of those minor children. If you have minor children and you're leaving assets to them, those assets will be distributed out at 18. You can't extend that without a court order. And they're going to list who's the fiduciaries, who's the ones that are going to be taking care of your, your estate. So in this case, if your estate is this real estate business that you've built, that you've put time and money into, and you want to have it for your loved ones to have after you pass, it makes sense to put documents in place to make sure that the rewards that you have earned to benefit them get to them in the way that you want them to. There's also things in the law that will occur that the courts will require if you don't have a will in place when you're trying to transfer assets, such as surety, having to go get a bond, an insurance policy for the value of your estate. And also there are certain shortcuts that you can include in a will just to make the transfers easier. So, I've touched on this a little bit about what can you do with a will already. It's the opposite, right? You can say who's going to inherit your assets. You can say how your debts are going to be handled. You can't get rid of your debts. Your debts will be there, but you can talk about handling them. You can talk about waiving bond requirements. If you list someone in your documents and you trust them, you can tell the court, I trust this person. They don't have to go and get an insurance policy for the ability to have assets transfer. In the case of a minor child, you can, or maybe someone else that isn't exactly financially sound, you can direct the trust be set up. And you can put limited trust discretion in that trust. Should it make sense in your circumstance to have a trust? The most common situations that I recommend that people use a trust is when they have minor children, when they have children that have substance abuse problems, if there's someone that is on government benefits and you want to get them some supplemental money, or if you've invested and you have real estate outside of the state, then I usually get a trust involved. The estate tax number right now is over $11 million per individual. So for a married couple, they have $23 million in exclusion before what in the 90s, they used to call it the death tax, right? It was all over the news, the death tax this, the death tax that. That is just not something that is at play for by far the majority of people anymore. So shifting assets into trust to protect against the estate tax is not normally what we're doing, right? In y'all's case, like with an out-of-state piece of property, the primary reason that I like to put out-of-state property into that trust is because of the process that happens after you pass. In order to transfer property after your pass, it's just like when you buy a piece of property and you got to sign, the seller signs a deed granting the purchaser ownership in the property, right? And that gets recorded in the land records. Well, when someone passes, something's got to get recorded in the land records, right? The court has to know and be able to show that someone has passed away. And so if you have a piece of property in a trust, that trust is the owner, right? They're in order to, just like they were discussing about how do you get a piece of property in an LLC, you get a piece of property in a trust by signing a deed, putting that piece of property in the trust. If you pass away and you have out-of-state property, then what happens is a probate estate would have to be opened in Virginia, and then a second probate estate would have to be opened in that out-of-state, whatever state it was in. My husband's from Florida. It's very likely at some point we'll have something down there as well. And the thought process there is I do not want to have to open probate or have my loved ones after we pass open probate in 2 states, right? Plus Florida is horrific. It's horrible. It is the nightmare that people say about for probate. I adore Florida for many reasons, but Virginia's probate process is astronomically better. So that's the kind of situation when I talk to people about trusts. The trust is a document where you can put even more controls in place, right? The will, the will is saying, this is where I want my assets to go. And it can be that you're saying, I want my assets to go to my spouse, to my partner, to my children, right? These are very simple to say that that's where you want them to go. And you can put, limited controls in there, but if you want any further controls, that's the purpose of the trust, right? You, just like the will, you can say who's going to inherit. You have more control in saying when can someone inherit. You can talk about, again, how your debts are going to be handled. If you are putting a business into that trust after you pass, this is a document that can talk about who's going to run that business, who can't run that business, right? If you have a real estate investment business and you've got a bunch of rental property, but you think your loved ones that you want to benefit from this can't manage those rental properties, this is where you can say who's going to manage that rental properties for you, right? How much of the profits can be used for the business to continue to grow? How much of the profits are going to go to your loved ones, right? Who can decide it's time to stop, the business? Who can decide to sell that real estate? And it's also a place where you can, choose to talk about what age can my beneficiary take over this real estate, right? When can they take control? And dictate the circumstances that they would be able to control the business. Really, this list is exhaustive, right? The process, and like I started with, and what the next steps are, is anytime that you are seeking to say, I want to protect where my assets are going and how they're going, then the process is to begin where we began, right? Is to talk with an attorney, whether it's myself or anybody that you feel comfortable with, and discuss your goals. This is what I have, and fundamentally, this is what I want to have happen with it. And if you can start with where your goal is, then just like in any area of law, any estate attorney is going to have different tools that we've touched on, in their arsenal to be able to use to meet those goals for you. I'm with Winslow, McCurry, and McCormick. Like I said, our firm is also do real estate closings, and we have real estate attorneys. We do all different areas: criminal, family, just bankruptcy, all different areas. So if anybody ever needs some help, please, feel free to give us a call. If we can't help you, we can refer you to someone that can. Does anyone have any questions?
Anybody have any questions? We give you a mic, so she'll be able to hear you.
Oh, I will note that the gentleman that asked about Florida and the LLCs, so I think what he was talking about was a couple of years ago now, Florida passed a law that basically said, if you're a solo LLC, those protections that we have, that we speak about, the whole reason to start an LLC, can be pierced much, much easier than they can here. So while Florida allows a solo member LLC to be pierced, quite easily, Virginia, as of the last time I looked it up, and it's probably January, the last time I looked it up, and I haven't seen anything because I think it would be really big and bold if it had, but Virginia has not followed course. Virginia, actually, the last case I saw on it said, we don't care that Florida is doing that. This is the whole purpose of having an LLC. We're not going to pierce it. So.
Thank you for your presentation. My question is, I had heard, just sort of talking with friends who had estate planning done, that real estate assets, when they're being inherited by multiple family members, how that can get complicated. Can you talk about that a bit?
Yes. So the general transfer of it, from the probate process, from the, like, you passed away and how does it get to it? If it's in your will and your will gets recorded, literally the day your will gets recorded, that property transfers to the people that you have listed. Okay. It may take some time for them to update online. So that aspect of it is not difficult. The difficulty lies in the fact that what happens if you leave it to multiple people and they don't all agree, right? Or what if a couple of them, if you've got 4 people and 2 of them are paying the taxes and 2 of them aren't? Or a worst case scenario, One of them's living in the house and they refuse to leave, right? They refuse to pay any of the bills. They refuse to pay any of the, the taxes, any of the utilities, and they won't go. That causes a nightmare for everybody. And then what generally occurs in that case is what's called a partition action. If you were concerned about property going to multiple people, that's a great place for a trust to say, who and what and when, right? Who's going to have control over this? Who's going to decide who can stay in the house? Who's going to decide if it's going to be sold, right? There's also certain language you can put in a will that basically reserves that asset and says, you know what? I know that it's supposed to be when this records, it automatically goes to the 4 people, but actually, Virginia, thank you for doing that. And that's normally what we want to have happen. But in this case, I don't think it's going to make sense. Please allow the people, the fiduciary, your executor, to be able to hold on to that asset and be able to distribute it or sell it or do what they need to do with it.
Any other questions? All right, I do appreciate it.
Thank you.
Thank you.
Y'all have a good night.
Right, so our next presenter will be Mr. Gordon. Take it away.
Hi, everybody hear me?
Yes.
My name's Curtis Gordon. I'm an attorney at the law firm of Dankis, Gordon and Tucker. Our office is on Parham Road in the J. Sargent Reynolds area. A couple things before I get started. I notice anytime I do these cameras always make my hair look like it's thinning. I can't understand why that's the case. And then the other thing is I'm pretty comfortable in saying I'm the oldest of the speakers here. So as the night wears on, if I doze off, bear with me, okay? Because that's what happens with old folks. So I'm going to talk about titling. I'm going to talk about a couple of kind of basic things, and then I'm going to talk about things that I run into almost daily that I suspect you're going to run into too when you're out looking for properties or trying to make deals happen. So titling in Virginia, simplest way. I own property in my name, Curtis Gordon. From there, we go to I own property with somebody else. Now, if I own property with somebody else, I can either own it as what's called tenants in common. If I pass away, or when I pass away, because that's going to happen to all of us, when I pass away, my share of the property goes to either my will, if I have one, or it goes to my heirs. And I'll touch in a minute who those are going to be. I can own property as joint tenants. I can own that with anybody. The last survivor owns the property. If I own property with someone as a joint tenant, I can also sell my half if I want to. I'm assuming right now I'll own it 50-50. That's going to become important too when you go out and talk to folks. Next thing is, if with my spouse, I can own property as what's called tenants by the entireties. If one of us passes away, survivor owns 100% of the property. I cannot sell or transfer my interest in the property without my spouse's consent. And finally, a judgment. If someone sues me and obtains a judgment against me, it will not attach to that property. Think of it this way. Legally, my wife and I'll say my spouse and I, are one person. So in order for a judgment lien to attach, there's got to be a judgment against both of us. Let me tell you why that becomes important. A judgment is when a court determines that somebody owes money. If you take that judgment and you go to the circuit court clerk's office and record it, it's called docketing in my world. It becomes a lien on any real estate owned by the person in that city or county. That becomes important because you'll find some deals where you get somebody to sell property to you and you get a title search done and you find out they have judgments against them. And they commonly say, well, that doesn't have anything to do with the property. It does once a judgment is docketed. It becomes a lien. Here's where that comes into play. You're out and you find somebody, a couple that's splitting up. They want to sell their house to you. One of them may have judgments against them. You really need to try to get that deal closed before they get divorced, before the judge signs off on the divorce decree. Because once they're divorced and the judge signs off on the divorce decree, then any judgments in that person's name is going to attach to their share of the property. If you can get it closed before they're divorced, you don't have to worry about paying off those judgments. That comes up all the time. Next thing that comes up, we want to talk about for a moment. This goes into a little bit about what the other speaker was talking about. Folks die, okay, pass away. That's probably also a significant portion of your leads that you're going to get. Who owns the property? Okay. If you have a will and the property is left to somebody, they own it. If you don't have a will, it's going to pass by what's called intestate succession. Let's talk real quick about what that is, because when you have to get a contract signed, you ought to hopefully have some idea who it is you're going to need to sign a deed or sign a contract and then later sign a deed. Okay. If you're married and all of the children you have are the children with the person you're married to, 100% of the property goes to that person. If you have a spouse and you have at least one child by somebody else, the spouse gets all of the gets 1/3 of the property, and all of the children split 2/3. Okay, so 1/3 to the spouse, 2/3 to all the children. I see that come up in this situation. One spouse had a child by somebody else years ago, haven't really seen or heard from them in years. They pass away. They have 2 children with their current spouse. Well, in my world, the spouse owns 1/3 of the property and the 3 children collectively own 2/3. So you've got to track down that child that nobody has seen or heard from in a long time to get them to sign off on the deed in order for you to be able to buy or wholesale that property if you're going to sign your contract to somebody else. Let's talk for a minute about when spouses need to sign off on deeds, because this also comes up all the time in my world. Hey, I'm gonna sell you this property. Well, we need your spouse to sign the deed. No way, they're not going to do that. They don't have anything to do with this property. I owned it for years before we ever got married. Here's the law in Virginia for that. If you own property in your name and you sell it or mortgage it for adequate consideration, now that's defined as money sufficient to support an arm's length transaction. If you sell it or mortgage it, which that's not much of an issue, because if you mortgage it for $500, if you get $500, that's an arm's length deal. If you sell it for for adequate consideration, you don't have to have your spouse join in. If you sell it for less than adequate consideration or you gift it, you need your spouse to join in. And here's the easiest way I find to understand that. In my office, my real estate assistant's been with me probably 25 years. I've been married for, say, 35 years. If I own a property that's worth $1 million, I can sell it for $1 million. Now I had $1 million asset of real estate. I've got $1 million asset of money. So if my wife and I split up, she's not really prejudiced by that because I had one asset and I've got the same value of another asset. But what the law would not like for me to see is for me to give my property to my assistant on Monday, who's also my girlfriend, and go to my wife on Tuesday and say, hey, we're getting divorced. And by the way, I don't have any assets anymore because I gave them all away yesterday. So if you convey property for less than adequate consideration, you got to have your spouse to sign. Here's where that's going to come into play for you folks. Our title insurance company has adopted this as a rule of thumb. If you're going to buy property for 50% less than 50% of tax assessed value. So if a tax assessed value is $100,000 and you're going to buy it for 45, they're going to want the spouse to join in that transaction. If that's a problem, there might be a workaround, but that is the easiest solution to that. If you find you're looking at something and a lot of your properties are going to be what I would call distressed properties, and you're going to buy it for half or less of tax assessed value, you really ought to try to get the spouse to join in. If you can't, there might be a workaround. There might be a workaround available, but the easiest thing is get the spouse to sign. Something else that comes up all the time. I'm going to talk a few minutes ago about judgments. Somebody's passed away. They've left property. They don't have a will. They had multiple children. I'll say 8, 9, 10, doesn't matter. Let's say that, let's say 10, and let's say property is worth $100,000, because I can think in round numbers easier than I can think in other numbers. Each person's entitled to $10,000. That's their share. 2 or 3 of those folks have judgments against them totaling $30,000, $40,000, $50,000. It doesn't matter, exceeds their share. A creditor in Virginia, they cannot attach an interest greater than the interest of their debtor. So in that case, if you got a judgment that's worth or that's $40,000 against somebody, they own 10%. The most that creditor can collect is $10,000. However, the challenge comes in is that I don't have the power, you don't have the power, the owner doesn't have the power to make that happen. Only a circuit court can make that happen. So you have to file a petition with the circuit court to have the interest in the property adjudicated and what each person's share is. Now, if we do those suits, because we do them not infrequently, let's just assume that that's going to run you a ballpark figure of say $7,500 in legal fees. What I suggest you do is you might want to go ahead and make your acquisition price inclusive of that. So if you were going to buy it for $100,000, say, hey guys, look, I'm going to have to wait 3 or 4 months for this to get done. I'm going to get this attorney. He's probably going to charge me $7,500. Instead of buying it for $100, I can buy it for, and again, if I could do math, I would have been an accountant. I'm going to buy it for $92,500. You know, price it in your acquisition so you can cover the cost of that. We touched briefly on a partition suit. Let's talk about that for a second, because that was one of the questions, and then I'll be happy to take questions. Somebody dies, they leave it to 10 people again. 7 want to sell and 3 don't. Typically 7 want to sell, 2 want to keep it because dad lived there and has emotional attachment, and the 10th person is living there and not paying anybody any rent. So they're the 3 people who don't want to sell. If you own any percentage of real estate in Virginia, you can file a partition suit. You can go to court. You can have the judge evaluate the property. And if none of the co-owners will buy it for what the court determines is fair market value, then the court will order it to be sold. And if you have a contract in place and if you can convince the court that's fair market value, the court will order that to be sold and you can acquire the property that way. Again, I suggest you price it in your acquisition price so you can pay those costs. All right, I've talked a lot now. Let me open it up for questions and I'll be happy to chat with, and if I don't know an answer, I'll try to make one up so it appears that I know what the answer is. Go ahead, what are the questions?
Hello, my name is Antonio. Thank you for your time. Okay, I have a case which I have a property that I want on the contract.
I'm not getting all of your, I apologize. I'm not getting all the audio.
Can you hear me now?
That's better.
Excellent. All right, so I have a property that I want to put on the contract. The owner was deported and the property is sold under his name, but he owes about $35,000 to the bank. According to the assessed value, is $236. I mean, $200,000. So my question is, what is his right? Can he still sell even though he's in another country deported? And if so, how can he get the money or how would that work?
Okay, I got some of what you were saying. So let me kind of repeat what I got. You have someone who's been deported. They own real estate here in Virginia, and you'd like to make them an offer to buy it.
Exactly.
Okay. Well, being deported doesn't affect their ability to sell the property. What it does, though, it affects your ability to get them to timely execute documents so you can get the deal closed. I suggest if you can sell it, you reach out to that person and get them to appoint somebody back here as their power of attorney. And you can have a specific power of attorney. You can say, I'm gonna let you do one thing, and that is to sell this real estate. So see if you can reach out to them and get somebody back here that they trust, that then it needs to be over 18. They need to be an adult, legally adult, that they can appoint to sign their documents. If there was another part of your question, please ask it again, because I didn't pick it up.
And then the second part, so let's say, example, he appoints someone and the bank approves me, and so where will the, like, let's say $20,000, will that be written a check to him and he would
will be mailed to his country, or the person that has the right will have to cash it? How would that work? I know that was his concern in regards to the monies, or how he
Yeah.
would receive.
Okay, I think the question was, all right, the money's available, and then how does it get to wherever the person is if they're overseas? Okay. Typically what we do is we could get wiring instructions. We could write a check and the power of attorney could send it to them. Now, when you get into selling property for people who are not US citizens, there are some tax withholding thoughts that we need to consider, but that is on the seller's part. That's not on you as the buyer. That would be something that they're going to have to deal with, whoever's doing the closing, whether or not they're going to have a significant portion of their money withheld. But as far as where the money can go, it can be wired, or you can overnight a check somewhere. We've done that plenty of times before.
So if I'm clear, just to close this. So pretty much you could sell, I could make him an offer. He would just have to get somebody that he trusts to write over a power of attorney, and then the monies, once the cash is out, it's his responsibility to take care of it.
Yes. Yes,
Take care of taxes or whatever. Okay.
correct.
Thank you so much.
Sure. Next.
Questions? Oh, man, nothing? I think you're in the clear, Mr. Gordon.
Somebody
It's
call-
all.
Yeah, please call me Curtis, Mr.
Yeah,
Gordon.
let's give a round of applause.
Thank you. Y'all have a nice evening.
So we're gonna put their information on the screen, and we just want to thank you guys so much for bearing with us throughout the rain and COVID. We want to give a special thanks to Jada and Chris for hosting for us tonight. You guys will see more of them. So it's not easy to get up and speak in front of people, so we want to really thank them for doing this for us. They did a great job, guys, don't you think? Especially for their first time. We also want to thank Miss Ebony and Jonathan and Mr. Seth in the back for helping. In Benit, where are you? I know Benit, where are you? I think Benit left. Oh, and Mr. Benit, so they will all be helping us, so you guys will see a lot more of them. And if you guys want to volunteer for us, let us know, because we always need help. You guys were so great tonight. Did everyone get good information? Get some good information, take some good notes? Nobody? No, Right. So you'll have something to present to us. Guys, we have these little things on your seats. Everyone should have one. These are our exit surveys. Oh, Brian, did you have something? Oh, so these are called our exit surveys. And Jada mentioned earlier that we need you guys' feedback so that we can get better. This really helps us, guys, a lot. The content, the people that we bring to speak, just everything that we have, you guys have literally given us the idea. So we ask that you guys fill these out. You can hand them to Jonathan and Ebony in the back, also myself and Oni. Oni is right there. Oni stepped out, guys, when we were introducing ourselves. So just wave for everyone. Anything else? Oh yeah, does anybody else? We had a few latecomers. Did you guys bring bills to people that jumped in late? Nobody?
I do want to add that I do have stuff in Norfolk and Newport News for any latecomers. You guys are interested in buying, they are fix and flips. I do have a couple buying holds, so get with me for your business card.
And what we'll do is we'll start we'll actually start trying to remember to put everything on Facebook if we have any deals, so that you guys can just go and check out the Facebook page, also Instagram. Yeah, so Facebook, you guys probably follow us there. You probably follow us, Meetup, Instagram, but we will also we have started our YouTube channel. And the YouTube channel has meetings like this where we put our older meetings when we first started, guys. Give it up for us. We've been here 3 years last month. 3 years. So those older meetings that we do have recorded, we're gonna put them on YouTube, so you guys try to follow us there. We do have a lot of information that, you know, some of our new people may have missed, a lot of speakers, home fillers, and things like that. But I think that's all we have enough people here to try and get about 5 business cards before we leave these. This is where the deals happen, guys. I've made a lot of money, and I can attest that a lot of other people have made money from Chesterfield. So you want to get these business cards, and yeah, thank you guys for coming. And again, Brian and everyone, thank you guys for speaking tonight. So.
Curtis, thank you. Sarah,
Curtis.
thank you.
Curtis, I thought you guys were gone, but can you hear us?
Yeah.
Yeah, I'm still here.
All right, thank you guys so much
Sure.
for sticking
Thank
with
you.
us and speaking with us tonight.
Thank you. Y'all have a nice evening. Bye-bye.
Thank you so much for having me. Y'all have a great evening.
You too. Thank you so much.
Bye-bye.
How did you feel?